Welcome to our training. Okay, so I'm just going to go through the PowerPoint, and I'm going to allude a lot to how it's different than the U visa, or same as the U visa. So luckily you've done the U visa training. Okay, so, dang it. That was sure working better. Okay. So unlike the U visa, VAWA is in the regular family-based immigration process, in just the regular petition-based immigration process. And I'll talk about the history in a minute, and you'll see how why that's relevant. And I think it is important to know the history, because otherwise you get kind of confused about what container you're in for deciding grounds of inadmissibility and things like that. But first I'm going to talk about the family visa process, which is a two-step process, as are most immigration processes. First, you have to show that whoever is submitting a petition is somehow eligible to submit a petition, and second, that the relationship that they say should exist actually does exist. So a U.S. citizen or a permanent resident can petition for their immediate family members. If it's a U.S. citizen, it could be for spouse, children, or parents. But the only person who can submit a petition for a parent is a U.S. citizen child over age 21. So you can't have a 5-year-old child petition for his or her mom. A permanent resident can just petition for spouse and children of any age. Once it gets approved, and probably anybody who's ever worked at a community meeting and seen people unfold an approval notice that has been folded and unfolded lovingly and carried with somebody many times, it's just the approval. All it did is show the relationship between the petitioner and the beneficiary, and that the petitioner had the requisite status. It doesn't mean that the application was, that the adjustment of status, that the green card application was approved. And a lot of people really get confused about that. It just means, yes, you made it over step one. It's the second step that's much more difficult. There are three categories: when, what, and where, that are all kind of critically important. The when, if it's for an immediate relative, it's immediate, which means you'll be done in about a year. Actually, sometimes 6 to 9 months. And it's only an immediate relative category if it's a spouse or a minor child of a U.S. citizen or a parent of an adult U.S. citizen. They can submit their application for permanent residency at the same time that the U.S. citizen petitions for the person to be able to get status. Anybody else, so like a sister or brother of a U.S. citizen or a spouse or children of a permanent resident, have to wait a long time. They have to wait their time in line, which is this archaic system which did not reflect how many people went to immigrate to the United States. So you can track that timing on the, not UA, U.S. State Department Visa Bulletin, and this is what that looks like. And you can get there by just looking at Visa Bulletin, just Googling Visa Bulletin, and you'll get the Department of State website that shows you this. Then you scroll down to the one that's family sponsored, and you can see that this shows the most common one we have. I was shocked to see how current this is. So F means family-based, and the category is F1 is children, adult children of U.S. citizens, and F2A is spouses and minor children of permanent residents. F2B is adult children of permanent residents. F3 is married children of U.S. citizens, and F4, that has a zillion-year waiting list in fourth preference, Philippines, is for siblings of U.S. citizens. So you can see it's a fairly stunning wait, although not so bad in second preference as it used to be. It used to be an 8 to 12-year waiting list, and now it's much shorter. So this is how long, if a permanent resident is petitioning for his spouse who is from Mexico, if that petition was filed before September 1st, 2011, she is now, as far as the when, eligible to start the process of petitioning for permanent resident status. So now here's the where. And the where is where the rubber hits the road, because we've got a very punitive system. the person can apply for permanent resident status if they're covered under INA Section 245A, which means that they entered legally, that's required, and either they're still in legal status, or they're out of status, or they violated the terms of their non-immigrant visa, or worked without permission, or something like that, if they are an immediate relative of a U.S. citizen. So a spouse or child can get around the still in legal status qualification, but not around the entered legally. You can only adjust your status under 245A if you entered legally. So that wipes out the majority of people that we would be helping. Under 245I, somebody can apply for permanent residence in the United States through this adjustment of status process if a petition was filed on their behalf, not necessarily the one that they're immigrating through, just at some point, like their aunt petitioned for their mom and they were listed on the application. That would be considered, that's called grandfathering in to find this date. So if their name was on a petition that was filed before February 20th, 1998, then they can adjust their status in the United States even if they entered unlawfully. There are two dates here. If it was 1/20/98, they don't have to show that they were in here in the United States at any particular time. But if they're going with the before April 30th, 2001 date, they have to show that they were present in the United States on December 20th, 2000. And we can talk at some other leisure about how they write immigration law so that you get all these wacky little things. But that's how it's written. It was done at 2 in the morning. They also had to pay a $1,000 fine. Okay, so everybody else, like pretty much everybody we serve, entered unlawfully, and so they have to go to their home country in order to be interviewed on their permanent residency application. As soon as somebody who has more than a year of unlawful presence in the United States leaves the United States, they trigger, is the word, a 10-year bar to being able to come back. So they leave to go to their consular appointment. They are barred from entering the United States for 10 years. There's a waiver of that is very difficult to get. You had to show that it would be an extreme hardship to a U.S. citizen or permanent resident, spouse, or parent if you couldn't come back. So you don't see children there. You can try to show that it would be an extreme hardship to your spouse if you were the principal breadwinner and she was sick and can't work, and so the children would somehow, their hardship would transmit itself to the spouse's hardship, but it's very difficult and there's no guarantee. So you have to leave the country in order to even be able to go to this interview, at which point you're barred, and then you submit a waiver application. There's a new process that has been put in place by the Obama administration called provisional waivers, where you don't have to leave before they decide. They'll do a provisional review of a waiver application and tell you whether they're going to recommend that it be granted or not. And so you'll know that before you leave, which is nice. Anyway, but we're not going to get into huge detail in that now. Just know that the family visa process is restrictive and punitive. If that person decides, oh, forget it, I can't wait for 10 years, I'm just going to come back into the U.S. unlawfully, they get something called a permanent bar, which is not actually permanent, but they can't even apply for a waiver to get back in for 10 years until they've been outside the United States for 10 years. So if they're back here, they are permanently barred because they would have to be outside to make it work. It's not going to happen if they're in the U.S. So the what is that the person has to be eligible to become a permanent resident, and so they have to be admissible under the grounds of inadmissibility, which are in INA Section 212 and 212A. They are mostly crimes, except for the most petty offenses. Immigration violations present without permission is the one we have on all of our U visa applications, 212A 6A. Unlawful presence, as I was describing earlier. Visa fraud or marriage fraud, any prior removals, alien smuggling, the same sort of thing that we're looking at with U visas. But they're serious in family-based applications as opposed to the U visa where it's it's forgiven very easily. They also have to prove that they're not likely to become a public charge. The petitioner has to submit a special form that says that they will that they make enough money to be able to support the immigrant, and that if the immigrant does ever ask for public benefits, that sponsor will be on the hook to repay whatever those public benefits are. Also, there are health grounds of inadmissibility as well. So, as bad as all that sounds, it is nevertheless one of the most appealing pieces of the immigration law is that a permanent resident or a U.S. citizen can petition for their spouse or child to be able to get that person legal status. And therefore, anything that valuable is going to be used as a tool of abuse by abusers in a wide range of ways. And the ones that are most common are the threaten to withdraw the petition. But I've seen a lot where they just never, ever apply. And they've never even raise it. They never even tell the person that she was eligible to be able to, that he could have applied for her. A lot of abusers will threaten to sabotage their interview when they go in, and a lot of abusers do sabotage the interview when they go to get their interview to get their permanent residency. Or they actually, instead of threatening, they actually do withdraw it or sabotage. And when they withdraw an I-130 application, at least in the past, ICE will almost automatically put that person in removal proceedings. So it's a great way to be able to abuse somebody. And so Congress said, we don't want the immigration law being used as a tool of abuse. And so with Joe Biden at the lead, the Violence Against Women Act was passed in 1994 with a gigantic array of options, including immigration provisions. So the Immigration and Nationality Act was amended in that family visa section to permit an abused spouse to self-petition for her own status. And the purpose was to not let the law be used as a weapon, and also to protect and restore survivors. And so the idea is that the survivor can self-petition. Is that from Marina? Mm-hmm. Oh, that's so lovely. So instead of having to rely on the petition process, oh my gosh. Oh, that's so sweet. So we'll talk in more depth about what the self-petition process is. That's pretty much everything we're going to be doing. The Violence Against Women Act was amended in 2000, 2005, 2008, and then just this last April. And generally it gets expanded a little each time. And what's kind of cool about it is that it gets expanded depending on the reality of the women, you know. And for a long time, well, from 1994 until 2000, if the abuser was deported or if there was a divorce, you could no longer self-petition because it was going through very strict. It was very strictly adhering to the old family visa process. So if the petitioner doesn't have status, then that very first step, they're going to say, well, you don't even have the status to be able to apply for permanent residency. We don't even approve that petition in the first place. Similarly, if they're divorced, they'll say you don't even have the relationship upon which to base a petition. But in 2000, the law was amended to include those two changes. The law was also amended to permit self-petitioners to adjust their status in the United States under 245I. Before that, they would have had to go to their home country to do consular processing outside. But we didn't have those nasty 10-year bars until 1996, so it wasn't that big a deal, and then they had to amend it to address the 1996 problems. More than you want to know? Okay. So here's what VAWA does to the family visa process. As I said, the regular system is that the petitioner files an I-130 family visa petition, but with VAWA it's the I-360. The I-130 is adjudicated at the service center that serves the geographic region where the petitioner and beneficiary live. The VAWA is only done at the Vermont Service Center in the VAWA unit, or the Family Services Product Line unit. And those officers, as we know from U visas, are very well trained on the dynamics of domestic violence and as well as immigration law. The standard is any credible evidence, just like with the U visa, rather than clear and convincing as it is with the family-based process. So that's just for step one. It's the I-360. And then the application for step 2 is, and we'll be talking more in depth about what it's going to involve, that for that step 2, it's going to be the same timing. If the VAWA self-petitioner was abused by a U.S. citizen, then she can adjust her status, quote unquote, immediately. And everyone, as I said, can adjust their status in the United States. That was only firmed up in 2008 if somebody entered without inspection, but they can. And then the interview is going to be at a local USCIS office, even though it was adjudicated. The VAWA is adjudicated in Vermont. The permanent residency has to be adjudicated in the home district. And she will still have to show that she's admissible to the United States or get waivers of her grounds of inadmissibility. And we'll talk a lot about that. Here's the differences between U visa and VAWA. And the reason that this is, well, it is relevant to you guys because you're so used to U visas. It used to be everyone was used to VAWA. And so they were really surprised when the U visa came along, and it's still taking people a long time to recognize that U visas are available outside of the domestic violence context, because it was always, we would meet somebody who was not VAWA eligible because her abuser wasn't a U.S. citizen or permanent resident, or because she wasn't married to him. So we were always waiting for the U visa to come along. But now we're all established with the U visa, and we only do VAWAs when we're dragged kicking and screaming into it. So in terms of the who, for the U visa, it's a crime victim who's been helpful. With VAWA, it's the abused spouse or child of a U.S. citizen or permanent resident. What they have to prove is, for the U visa, we all know that they were helpful and suffered substantial abuse. With VAWA, they have to prove that the abuser was a U.S. citizen or permanent resident, and that there was a valid marriage and there was abuse during that marriage. There is no action needed by a government agency in VAWA, whereas you need a certification for the U visa, which is the one way in which VAWA is easier than the U visa. And necessary documents, we'll talk more about what they're needed, but totally different groups of necessary documents. And in terms of derivative beneficiaries, the U visa is a little more generous than VAWA. With VAWA, it can only be the minor child who is going to be eligible as a derivative. If the child was the self-petitioner, their non-abusive parent can also. But generally, each application only has one category of derivative, as opposed to U visa, where it's such a wide range of people. Disqualification with U visa is only pretty serious crimes, whereas with VAWA, it is there are certain immigration violations through which you can't even get VAWA, and you can't even do the first step. It's just less generous waivers on other things. The eligibility for work authorization, it's with both of them. It's only when the application is actually granted, but there's a nice little twist with the adjustment of status application for VAWA, where it's a U.S. citizen abuser, that they can apply for their adjustment of status application at the same time, and with that adjustment of status application, the person becomes eligible for a work authorization. So they are work authorized as somebody who is applying for permanent status. So VAWA cases, we get the work authorization in about 2 months, which is pretty nice. I don't know if it's as nice as having to do VAWA. And then the path to permanent residence, with the U visa, it's 3 years. With VAWA, it is either, if it wasn't an immediate relative, it's that long waiting list that we were talking about on the visa bulletin. Although it's only 2.5 years, 2A from Mexico, which is sort of amazing. And if it's a U.S. citizen, they can apply immediately with their VAWA application. And what happens is that the Vermont Service Center will hang on to the adjustment of status application while they adjudicate the I-360 VAWA application. And as soon as they approve the I-360, then they forward the adjustment of status application through the regular immigration process. But it's kind of done by them with a little VAWA approval attached to it. So it kind of has its own little protected way through the process. Travel, with the U visa, it's possible but challenging to do it before somebody's a permanent resident, and with VAWA, it's not possible at all to legally travel. With just the VAWA approval, you have to wait until permanent residence. So those are the differences. Who can submit them? I already sort of said this. Spouse of a U.S. citizen or a permanent resident, either she has suffered abuse herself, or even if she hasn't suffered abuse, her child has suffered abuse. But she still has to be married, right? So there, you still have to have this spouse connection. Or a child of a U.S. citizen or permanent resident who has suffered abuse can also be a self-petitioner. In addition, as I alluded to earlier, because you guys already understand derivatives, if there's a mom and child, the child can be the derivative rather than having to self-petition. So if both mom and child are abused by the father, it's often easier to do the mom self-petition and have the child as the derivative, just because it's easier on the child not to have to go through the whole process. But sometimes if you're not sure about the mom, you're going to go with the child being able to do it as well. It's somewhat similar to the U-Visa considerations in terms of how much it will burden them. And the other person who can self-petition since 2008 is a parent of an adult U.S. citizen, because elder abuse has been detected, although I don't think anybody has, I haven't heard of any applications being submitted yet in that category. The requirements are, we already said, spouse, child, or parent of a U.S. citizen or permanent resident. They have to have been subjected to the abuse during the qualifying relationship, the marriage. They have to have resided with the abuser at some point during the marriage. They have to reside in the United States with some exceptions, and they have to prove that they have good moral character. Okay, the first of these is spouse, and that has two components. The first component is that it was, in immigration terms, a good faith marriage. And what that basically means is not that it was the greatest marriage in the world. Really, it is only supposed to mean that it was entered into without fraudulent intent. So if you've seen the movie Green Card, and if you haven't, spoiler alert, oh, you guys have probably seen the recent one. I only know the old one. If Andy McDowell had abused Gerard Depardieu, which there's may be reason to do, then he couldn't apply for VAWA because that was a fraudulent marriage. They entered into that marriage for the purpose of defrauding the immigration service. And so they would be excluded from that good faith marriage requirement. Interestingly, you do have to show a lot of really a high level of good faith marriage, though. It's supposed to be when you entered into it. It's supposed to be when they make the determination, like, did you intend to have a real marriage? But they make, in VAWA cases, as well as other family-based immigration, they make you show like a great relationship all the way through, and they can deny if they don't feel like, it was the best relationship in the world. Not fair, can be fought, but it's one of the things we really endeavor to prove. It also has to be valid in the jurisdiction where marriage took place, which means that in California it could be a same-sex marriage that could be the basis of a VAWA application, which is pretty darn magnificent. The other reason a marriage might not be valid is if it was a bigamous marriage, either intentional or unintentional. And we do find these sometimes where either the abused spouse or the abuser was married when the qualifying marriage took place. So the qualifying marriage is not valid. There's a small exception to that with the completely confusing name intended spouse, because when you read the words intended, you're like, intended? They intended to get married, so she should qualify. Instead, intended spouse is this tiny little exception to the rule that it has to be a non-bigamous marriage, that somebody has to be free to marry at the same time. If it was the abuser who was the bigamist, and the abused spouse really believed that he was free to marry, and they actually did have a wedding ceremony, then they qualify for the intended spouse exception, and they have a valid marriage. They also have to either be currently married. That was the 1994 law that tracks the regular family-based process. Or since 2000, they can still self-petition within 2 years of the divorce becoming final, but they also have to show a connection between the divorce and the abuse. So on to the child definition. The definition of a child, and you'll want to know this for other reasons sometimes anyway, so that's why I'm going into it. A child is unmarried, except in the case of a well, never mind. Okay. Child is always unmarried in immigration law, with one tiny exception in the U visa. Unmarried and under 21, and has to either be born in wedlock, or if they're born out of wedlock, that they've been legitimated, or are in a bona fide parent-child relationship with the abuser, or a stepchild, and a stepchild is a child for immigration purposes if the marriage that created the step relationship occurred before the child turned 18, or adopted, as Vicki was able to analyze recently, if they were adopted before age 16 by the abuser and had at that point already resided in the legal status of that abuser for 2 years before the adoption was formalized, which all has to happen before age 16. So I've never seen a case like that. Another change in VAWA is the child may file, even if they are not still a child technically, if they're between 21 and 25, if they can show that the abuse by the parent was one central reason that they didn't submit their VAWA application in time. None of these have been adjudicated. It's not clear whether, like, the entire time, like, can you wait until you're 24 and 364 days, and just because there was some abuse when you were 21 and 1 day, you can have waited that extra 4 whatever years? We have no clue, so I don't think they know. But someday we will learn that. And don't forget that any children listed on the parent self-petition can derive the benefits, so they don't have to self-petition on their own if they can do it through a parent. Okay, the status of the abuser is that they are a U.S. citizen or permanent resident, and a U.S. citizen can never lose their status because of a crime or anything like that. They have to go through a really formal renunciation process that's extremely difficult to do, and that's not going to be most of these. So when we talk about losing their status, we're talking about losing permanent resident status. And that's usually going to be because they have been arrested and deported. So the day that they lose their permanent resident status is the day that they're ordered deported or that they are actually deported. So if the self-petitioner can prove that the loss of status was because of an incident of domestic violence, she can also submit her self-petition within 2 years of that deportation. This is a lot of things to keep in your head, isn't it? Yeah?
Good stuff. Because I had one where he was deported, and then Jess was like, was it because of the domestic violence? And I said, no, it was a robbery. And she goes, okay.
Darn. Yeah. Bummer. But see, that's a really typical thing. And mostly it's Vicki who's having to do a lot of these screenings.
I was like, oh, that's good to know.
Yeah, good. And I actually have a really in-depth screening form that I should give you. But anyway. We don't want to overdo it at the screening process because then you'll never get off the phone. Okay. So the big thing that we have to prove in a self-petition is that there has been battery or extreme cruelty. So battery is physical abuse. Extreme cruelty is mental, emotional, financial abuse. It's the same sort of proofs that we're going to be doing for the substantial abuse for U visa, except there usually isn't the same level of proofs. For one, because I haven't seen the same level necessarily always of physical abuse in VAWA cases. And I don't know why that is. I don't know whether it's because if it's worse abuse that the police do get called and he is arrested, so she goes with the U visa, or if actually VAWA self-petitioners are more empowered and so they are getting out of the bad relationship sooner, or what. Actually, I think in LA there's a lot of physical violence in VAWA cases. Up here, honestly, there is not as much. It's really an odd thing. So we often end up doing VAWAs based on extreme cruelty, which is the mental, emotional, financial. And in addition to the kinds of proofs that we use for the U visa, we will often use a lot of witness letters, and we'll talk about that when we talk about actually putting together the application. But it's going to be any act or threatened act of violence, any detention, the same sort of things as I said for the U visa. Any kind of what the Immigration Service says it's looking for in addition to physical abuse is the intentional diminution of life's of her well-being and her life's hopes and dreams, and the degree to which he is controlling her to an excessive degree, or humiliating and, like I say, diminishing her as a person. So a lot of our emotional abuse materials that we have for the U visa were originally created for the U visa, and they go both ways: substantial mental abuse for U visa and battery, extreme cruelty during for VAWA are pretty much the same. It's also worth noting that they say that abusive actions, that a long line of abusive actions, just like with the U visa, we say substantial abuse if it's domestic violence. You can look at a whole history of abuse. With VAWA, they actually spell that out and say if a single incident of domestic violence is not sufficient, we look at the entire pattern of. So if he only ever pushed her on one occasion, if you look back and you see all these other things that happen, or if he, even if he was just exceptionally cruel to her on one occasion, you're going to look at why that cruelty was so much more intense because of the whole history of abuse during that relationship. And also the immigration. So this is a list from immigration, but they really want to say this is not an all-inclusive list. There may be more. We don't want to tell people that they won't be eligible because they don't have something on this list. Although they will RFE you if they feel like what you gave them is not sufficient. But they specify that actions against something else, like a dog or even your car or another person, if that action was meant to convey that the self-petitioner is at risk of that same kind of injury, that those are sufficient. But as with U visa, you have to you can't just tell the Immigration Service, this happened and then this happened. You have to draw the logical connection between those two things self-consciously, or you might get RFE'd on it. So residence with the abuser, I've only had a couple cases where that's an issue, like where they're homeless and things like that. And also she has to be residing in the United States at the time of submitting the self-petition, unless there's some exceptions basically for military spouses who are living on U.S. bases and things like that. Good moral character has two components. The first is the statutory bars in the statute at 101F, and we will get to those in the next slide. Those, if you have one of those, then you are barred from being able to show good moral character. And in addition, even if you make it over that hurdle, the Immigration Service can hold certain things against the self-petitioner in their discretion, which is like a community standard. And I haven't seen that exercised much in the VAWA context, but in the naturalization context, it's things like not supporting your children, not paying your taxes, and other sort of, anyway, those are the two examples I can come up with. The applicable period, VAWA doesn't state an applicable period. What they say is that they want evidence of good moral character for the 3 years preceding the filing of the self-petition. But I've seen cases in which they actually do deny for something that happened before the 3-year period. I think in those cases they probably have some particular animus against that particular self-petitioner, because that's more than 3 years is a lot, and usually they don't. Usually if there's a good moral character problem 4 years ago, it's not going to be an issue for VAWA. There are waivers. So usually when we talk about waivers, we're talking about inadmissibility waivers. But in this case, we're talking about waivers for the good moral character requirement. So remember, we're still talking about the Violence Against Women Act self-petition itself, not for the permanent residence application. So there isn't an inadmissibility determination at the VAWA stage unless you're applying for adjustment of status at that same stage. Instead, it's just with this initial application. But you have to show good moral character. And good moral character is so similar to the grounds of inadmissibility, it's so easy to get them confused. So just know that it's going to be really counterintuitive for a while, and you'll need to talk it through with somebody, because it really is just too hard to accept in the abstract. But putting them back together to cause more confusion, there is a waiver of the good moral character ground if There is a parallel waiver for the parallel ground of inadmissibility, and there's some that don't have it. And in your packet, there's an awesome chart that was created by the Immigration Service of the good moral character grounds that don't have a parallel waiver to the grounds of inadmissibility. Even if you can show that there would be a waiver of that ground of inadmissibility, if it were a ground of inadmissibility rather than a ground of bad moral character, you had to show that the violation is connected to the abuse. So one of the ones that you'll see is prostitution within the last 10 years before submitting an application. So there is a waiver of that available, and then there is, and that's in that memo. And then if you can show that somehow that prostitution was connected to the abuse, because sometimes it's the pimp that's the abuser, and those are the only 2 cases I've ever had. It was the abusive spouse was also the pimp. She was able to show that connection. It's not always that easy. So the statutory bars are a little broader, actually, because they've got all the, actually, no, it's the same. So gambling, illegal gambling, all those kinds of vice, alcoholism, drug abuse, in addition to crimes involving moral turpitude, alien smuggling, prostitution, like I said, mostly criminal offenses, and also some health offenses as well. The one that there are 2 that are actually, I've only got 2 of them listed here, but there's 3 because I was talking to Mona today about another one. So false testimony for the purposes of obtaining a benefit, which is oral testimony in front of a decision maker. So in front of a court is generally in the Ninth Circuit. They say it has to be a tribunal. But it's arguable whether at the border, if you told an officer under oath that you were a U.S. citizen and you weren't, that would be false testimony. So it has to be oral, it has to be under oath, and it has to be in some kind of tribunal that we'll look into if you have such a case. That's a bar to good moral character. You can't even self-petition, or you can't win your self-petition if you have false testimony. Similarly, if somebody is convicted of an aggravated felony after 1990, they can't waive that ground of good moral character. And remember that good moral character is longer than 3 years. If you have one of these things, it can go back forever. Now, you might say that's an interesting equivalence between an aggravated felony and false testimony for the purposes of getting an immigration benefit. The other one is being a drug abuser. The rules enacting the drug abuser ground of inadmissibility, and therefore of good moral character, say that if the last use was more than 3 years before the medical exam, then it can be waived, so that is technically waivable, but only after 3 years. So those are where we're going to run into trouble with VAWA cases. Okay, so now we get to talk about the process. The form is the I-360, and we'll be going through it. And we have, just like our U-Visa case starter templates and all that sort of stuff, we have a VAWA state folder in the shared drive. And then, as I say, it goes to the Vermont Service Center in the same places for the U-Visas. We get a prima facie eligibility notice, usually about 3 or 4 weeks after we submit the application. So with U-Visa, we get the receipt about 2 weeks later. And with a U-Visa, somebody is eligible for public benefits the minute we submit the application. But most public benefits agencies don't actually get the person signed up until they can give them a receipt. So it's a little sooner than with VAWA, where they have to make a prima facie eligibility determination, which they do by looking through and making sure that there is some kind of document for every requirement. So I did a skeletal application that now I'm trying to turn into a full VAWA. It's called skeletal, and it's just like you just have one little document for each thing. So it's a clerical determination. It's not an official adjudication by an a USCIS officer. It's done by clerical staff. They just look through and see if you have something for each thing. And then they give you that prima facie eligibility determination, and the applicant can apply for public benefits with that, in California at least. Right now, it's taking about 18 months to even get an RFE on VAWA cases. They are just sitting there on somebody's desk for 15 to 18 months. And then, which is really terrible if there's not an adjustment of status application with it, because it means no work authorization, nothing for all of that time. And usually, so around 12, 15 months, as soon as it gets on an adjudicator's desk, if they find something they don't like in it, they'll send a request for evidence, and you get 60 days to be able to respond. And so if you feel like you're going to get an RFE, you should start having a plan to work with the applicant early on to start gathering whatever is needed to overcome that. Even if you needed to submit the application when you did, you want to be working on beefing it up in case you anticipate an RFE. Lately, the Immigration Service has got a bunch of new adjudicators, and they have been appallingly bad VAWA RFEs. Some bad U-Visa ones, but the VAWA ones are just like they didn't read the law. They don't know what the standard is. So there's a project to try to get that fought back. Hopefully we won't get too many. And then with approval, somebody gets deferred action, which is just like deferred action for childhood arrivals. What deferred action means is that the Immigration Service knows that you're in the country and it's not going to take any action to deport somebody. And when they're in that deferred action land, it's not actually a kind of legal status, but when they have deferred action, they are eligible for work authorization with that. And they have to reapply every year. If it was a permanent resident abuser, so they're on that waiting list determined by the visa bulletin, they have to continue to renew that deferred action status and their employment authorization every year, because it's only good for a year. And then they can apply for permanent resident status when the WIN comes up. So the form itself, you have it, no, I didn't put it in the packet. So I got to exit from here.
I have a question about the EAD. Does it come with the approval, or do you have to, like, once you get the approval, you do the I-765?
Bingo. Yes, once you get the approval, the I-765, which adds to the time that it's going to take to get it, which is unfortunate. So here's the I-360 form, and mostly I just have this here. I tried to scan it so that the yellow would show, but I mostly have this here. Yeah, it kind of shows a little bit. I mostly have it here so you'll see how little of the I-360 that you fill out. So we make it as care of us at our address, not only because it's not safe from the abuser, so we wouldn't want the Immigration Service to send anything to the home address for that reason, but also we just want to make sure that we get all the notices, that they don't get lost. So that's why that's our address. And then, where was it? Then you're going to check I, self-petitioning spouse of abusive U.S. citizen or permanent resident, because you can see that this is a 12-page form for every kind of special application in the world. And then this is the information for the applicant, and once again we use our address. And then what's important to me. So generally they're still going to be married. If they are now divorced, make sure that you're looking for that 2-year deadline and the connection to the abuse. Date of arrival, we have always interpreted as their date of first arrival in the United States. We'll compare that in a minute to the I-485 and the I-765, which ask for the date of last arrival. And those of you who've worked on DACA cases know that that can be an issue. Somebody may have triggered the 10-year bar or the permanent bar or something like that. So if she first arrived in 2003, then she left the U.S., and then she comes back in 2005, 2005 is going to be on the I-485 where they ask for their last entry to the United States. So this is where the Immigration Service, who knows whether this was their intention, but this is where they find out that somebody has left the United States and may have triggered one of those bars. So it's really important to always be very careful about the date of arrival. And you guys know from U-Visas that you just have to brainstorm with the applicant as best as you can. Okay, and then we skip part 4. And then, skipping, page 4. This is information about the abuser. And so you're going to have the abuser's name, date of birth, country of birth, and then whatever his or her status is, and you have to provide their A number or their naturalization number if you can get it. In the case that I filed as a skeletal case, the reason that I filed it was that she didn't have any evidence that her abuser was a permanent resident or a U.S. citizen. And so in order to ask the Immigration Service to do it, they will not give information to somebody other than the petitioner, him or herself, about his status. So for privacy reasons, they will not, you can't, we used to be able to write to immigration and say, is this person a permanent resident? Can you tell us? And they won't do it. They'll only accept an application as an inquiry into that status. And then if you don't submit a skeletal application that's prima facie eligible, they will bounce it back to you. So in order to find out if the abuser is a permanent resident, you have to submit a VAWA application. So anyway, that's it. The thing is, I understand the privacy concerns now. So I didn't at the time. So that's where you're going to find that out. And then how many times they've been married. This is where they're looking to see if it's a valid marriage in the state. And then the date and place where they were married. So you need to put all that. I don't know why. I frequently see that either the date or the place skipped over. And then the dates, number B4, are when they stopped living there too. We skipped 5 and 6. Oh, no, we skipped 5. And then this is their last address together and the date they last lived together. Those are important because if somebody's still living with the abuser when they file for their permanent resident status, it could raise a question on immigration's part about whether that was, whether there really was abuse during the marriage. It used to be that at the district offices, and it could be other places, it is still like this, they do not trust the Vermont Service Center. They think it's all just a bunch of Vermont hippies, and they're just going to approve any old thing, and that it's their job in the district offices to talk to the person face-to-face to find out really whether there really was abuse. That was a plague in San Francisco for quite some time, and it has, Jess and I have gone to maybe 10 VAWA adjustments in the past couple of months, and it hasn't been asked once. I mean, they ask these dates and no more questions. It's beautiful. So they're letting Vermont be the adjudicator. But you still have to put this. So I do feel nervous if the couple is still living together. Who knows if that's going to raise a question in the adjudicator's head. And why would somebody be fraudulent? I always used to wonder this, but then I realized it's because you can adjust status if you're VAWA if you entered the U.S. without inspection. Whereas if you're going through the regular family process, you have to leave the United States if you enter without inspection, so you'll have the 10-year bar. So it could be that people could conceivably fake the abuse so that she can get her status through 245A through VAWA rather than having to go through him. And I've actually suspected two people in my 10 years of VAWA, and we didn't represent them. It just didn't. The case didn't smell right to me. Doesn't mean they can't go to somebody else, but anyway, I like to maintain our honest relationship with immigration. And both of those were ones where they were at the interview, her adjustment of status interview, and the examiner said, she's not eligible to do this. So there's a finding in the immigration records that she's really not eligible to adjust. So anyway, I wasn't just being mean. And she said, and therefore we came to you. Okay. So they're asking if your children have filed petitions, and you would know that. Okay, now is where we get skip all the way until page 8, I think. Is this a waste of paper or what? Okay, so information about the spouse and children. It's always going to drive her crazy to put information about her spouse here because he is the abuser. She's not petitioning for him, but you just have to assure that that's how the form is written. And as long as they're not divorced, even if they're separated, even if they are in the process of divorce, she needs to list him here. It's not going to hurt her in any way to have her here. And then their children, any children that she has, and remember the definition of a child is in wedlock, out of wedlock. We know from the U visa, in the United States, outside of the United States, stepchild, every child needs to be listed here. And if they're not, immigration will put up one eyebrow and scowl. And then she signs. She signs here, but this is where USCIS is going to sign. So the applicant signs here, And I've never put the email address for an applicant. And then here at ICWIC, it's the attorney who reviews the cases and assigns it. So that's the I-360. Wasn't that exciting? Okay, so now we can go back to the process. How's our time? Okay. So I have a cover letter that includes all of these things in your materials at the very back. Did you get cover letters? So you don't need to take copious notes on these little itty-bitty things. But basically, it's all the forms and then some kind of documentation of each of those requirements that we discussed. So the requirements sound very nice in the abstract until you realize you have to prove it with documentary evidence. The reason that they accept any credible evidence is because there is this congressional determination that abused spouses don't have the same access to documents and things. Often, as part of the abuse, the abuser will keep those documents. I had an applicant once who said her father, in this case it was a child self-petitioner, just ripped up the I-130 right in front of her eyes, and that was actually sort of part of the abuse. And those are the cases in which you can use the Freedom of Information Act or the Privacy Act to ask immigration for somebody's file. I submitted a Privacy Act request 8 months ago and have not heard a word since, so that will take you a really long time. The other thing that is possible is that you can file a skeletal application and write all over it, you know, the reason I'm doing this is to see if he really is a self-petitioner in the first place. So don't reject this just because it's skinny. So that is one possible way to find the abuser's status. And then hopefully she's got a copy of the marriage certificate, or it is a public document. So you're sometimes using, you know, the various public documents rules. So often I haven't seen the marriage certificate as difficult. The worst thing is his status. And so you can get affidavits from people and all this. There's actually been a little conversation on the VAWA experts listserv where the abuser was a U.S. citizen by birth, so immigration doesn't have any evidence of that because he's not in their system. And so she's having a really hard time being able to prove that that he has U.S. citizen status and therefore she's eligible for VAWA. In which case, she's going to have to put on a big old hanging argument about what the standard should be and all that kind of thing. So there's actually in the front of the VAWA manual, which is a green manual over on the shelves over there, there's the whole first chapter is just about document gathering, although we'll probably have a lot of that stuff easily at hand. Just ask me or Jess for it too. So anyway, the cover letter is a lot more extensive than the U visa cover letter because you're having to show documents of each part of all of this. So here's how we do it here at ICWIC. We start off when they call Vicky, and she does the preguntas iniciales that you have here, where she's basically asking each of the requirements. Were you abused by a U.S. citizen or permanent resident? Were you married to that person? Did it happen during the marriage? And were you, just briefly, how were you injured by him? And then we do a little bit of stuff on admissibility. So that's what Vicky does. So you'll know that the person's probably eligible by the time they come to you, unless they've got one of these wacky things. And we do 3 appointments. We shoot for 3 appointments. I find VAWAs to be a little harder because of the adjustment of status application. Sometimes I need a whole separate appointment just to do the adjustment of status and work permit and all of that sort of stuff. But we aim for 3 appointments. I find VAWA declarations to be more like 6 to 8 pages rather than 2 to 3 pages as they are with a U visa case. So that's going to take a little bit longer for you. And the reason is that the VAWA declaration, as we'll discuss in just a minute, is with U visa it's like, this was the crime, this is how I suffered, this is how I was helpful. Whereas with VAWA you need to talk about how they met, how they decided to get married, because the good faith marriage is a big part of the VAWA application as well as the abuse. And so we don't ever really have to deal with that very much in the U visa. And so you're having to say it was a valid marriage and then it went bad. And so that's an excruciating thing to go through also with domestic violence survivors. I mean, you know that U visa DV cases are harder, the decks are harder anyway. Well, add to that forcing her to talk about how the marriage was good and how it went bad. So anyway, we try to do it in 3. That's all I'm going to say about that. So we have an intake form for VAWA just like we do for the U visa. And if you fill them all out, then you can determine authoritatively that the person is eligible, and then we'll do a roadmap on it. And then there's the declaration and documentation review. Oh, so also in the intake, you go over the document list, which we have here, and it's a 2-page list. And it's the same basic stuff as the U visa with FBI reports and things like that. But then it's a lot of stuff to prove the good faith marriage and to prove the abuse. And more than we do in the U visa by far, we use affidavits, or not affidavits, we use declarations or even letters. A declaration is under penalty of perjury, an affidavit is a notarized declaration. Letters have always been completely sufficient. USCIS uses the term affidavit, but they accept letters all the time. And so the letter ideally is extremely detailed and very descriptive. It doesn't just say he would, she was always crying every time I'd see her because she said he would always push her. That's not detailed enough, although I wouldn't turn it away. I would submit it if that's as good as they can do. But the more detail about how the person knows about the abuse, the better. In some cases, there are no witnesses to the abuse because control and isolation are part of the abuse. And so a letter about how she used to be such a sunny person, they could do things together, and then as time went on, she was never able to see her friend. And every time she did see her, she was depressed, she was crying. We often use those kind of letters in a VAWA case. So that's another reason that a VAWA takes a little bit longer than others, is that you're having to beg her to bring you letters and then to amend those letters. And then the last appointment is collecting more documents and going through the I-360 form and the I-485, I-765, G325A, which we'll talk about in a minute. And then we submit the application and it gets approved, and then we represent the applicant at their interview downtown San Francisco.
And we charge extra for that, right?
Yeah. The adjustment of status application fee includes preparation, but yeah, it's $300. So it's $600 for the forms and the interview preparation here in the office, and then an additional $300 for the interview representation. Good question. So the declaration, as I said, you had to go into each of those requirements, including good faith marriage and good moral character. You don't have to have a separate category for we lived together and I lived in the United States. These are the main 3: good faith marriage, abuse, good moral character. And we have a ton of, maybe they're even in here. Yeah, I have a list of some of the models. Not as many as with U visas, because we don't do as many VAWAs. But Sarah Roselle helped me make this power and control wheel. Did I show this to you? I think I did in the U visa training. So there is a power and control wheel that is fantastic for helping somebody recognize that they have suffered from domestic violence, but it isn't necessarily strong enough. It's not necessarily the case that you can identify something on one that's done by the Duluth Domestic Violence Project. If somebody has something on there, it doesn't necessarily mean that they're going to win their VAWA case, which is why we added sort of that he's intending to do these things to her and that she ends up feeling that way. You need to draw those connections. Because, for example, maybe he's just a jerk. Maybe he's doing drugs and he's not intending to be harmful to her. Immigration will require you to show this, that he was intending to harm the quality of her life, diminish control, humiliate her. And luckily they've sent out enough requests for evidence that we've been able to find patterns in what it is that they want, which is what this power and control wheel was based on. The other way, of course, that you can help her identify abuse is with showing her the cycle of violence, so that each of those outbursts, whether they're physical or emotional, are a part of the whole pattern. It's the whole pattern, including the roses and the apologies and telling her she's beautiful, and her walking on eggshells are as much a part of the pattern of abuse as the explosion is. So here's what we have to prepare for your declaration appointment. Same sort of stuff as the U visa. So there's a whole emotional abuse packet that has a lot of sections from VAWA declarations that I helped applicants rewrite when they just couldn't get down to just determining that they had been abused. Jessica Farb calls it anti-romance novels. And then there's the questionnaires and things like that. So anyway, the emotional abuse packet will help you walk through being able to help her understand how much she's been abused. And just like with the U visa substantial abuse, there's the PTSD questionnaire, and then there's the tools that therapists use for depression, anxiety, and all those sort of things. As I think I mentioned once, Josh Rose from Family Works Community Counseling, when I wrote to him and said, how come you only ever write about PTSD and depression? Why don't you talk about anxiety? Why don't you talk about other kinds, sorts of mental or emotional disorders? And he said, because it needs to be tied to the crime. You know, you can't say that something that she's had for a long time is necessarily tied to the crime. Whereas with VAWA, where the abuse has been going on for many, many years, you do want to look into whether she's got anxiety and things like that aren't necessarily tied to just a single incident. So that's what's in here. And then here's some model declarations. Sometimes it's hard to show. Anyway, there's often a tension between emotional abuse and good faith marriage. And one of the problems is that VAWA applicants frequently leave a marriage as soon as it gets bad. One of the most typical things that we see is someone who, well, certainly arranged marriages where the abuser petitions for somebody to come over on a K-1 visa, and then he doesn't marry her. If he doesn't marry her, she can't do VAWA. If he does marry her, and then the abuse becomes worse, she's like out of there. And so you can't even show the good faith marriage. You can show sort of the abuse, but they actually never really entered into a marriage that wasn't going to be fraudulent in immigration's eyes. So that's why we have those models there. And then somewhere there's physical abuse before the marriage. That's one of the problems I most often run into, is that you've got an 8-year relationship, but they only got married 3 years ago. And the abuse actually did taper off, but she's starting to see signs of it again, and he won't petition for her. And therefore, you're having to show that during the marriage, she's being emotionally abused by being constantly reminded that he could become physically abusive again. So that's what that one is. Like I say, you have to document